All right, good afternoon and welcome to our December webinar, Serving Domestic and Sexual Violence Survivors Through Child Protection Matters. I am Ty Cinnabon, Advocate Support Program Manager at Standpoint. Presenting today is Amy Eisner, Standpoint Senior Staff Attorney. A little bit about Standpoint. We are a statewide organization. We are a team of attorneys and advocates working together to assist individuals who experience domestic violence, sexual violence, and trafficking. And not only individuals who have experienced that, but we also assist systems providers as well, who interact with those survivors. And we do this by facilitating trainings, answering calls to our action line. And our action line is answered Monday to Friday from 9 a.m. to 4 p.m. And our attorneys will provide legal advice to survivors, and our advocates will connect with callers with resources, help safety plan, listen, identify possible options through our action line. And we also do lots of trainings around the state of Minnesota. One of the major trainings that we do at Standpoint is the new laws training. We do 6 of those a year. And our monthly webinars, which this is one of them, for advocates, and we do lots of trainings by request as well. So endpoint is that we are here to assist you. So please reach out to us with any questions, any training topics that you would like to see. But as for today, I am helping facilitate today's webinar for Amy Eisner. And so if you have any questions during her presentation today, there is a question and answer tab on the bottom of your screen and also a chat tab. So go ahead and type your questions in there, and I will give them to Amy when there's a break in between her topics, and then she can answer them today. I have also uploaded into the chat tab the link to the PowerPoint that Amy is using today. So if it would be helpful, you can go ahead and print that PowerPoint out and follow along, take notes if that's helpful for you. Also, a reminder that we record all of the webinars that we do, and I upload them later into a YouTube page. Okay, Amy.
Just as I took a drink, I knew. Welcome, everybody, and thank you for joining us today. Like Ty said, we're going to be talking about serving domestic and sexual violence survivors through the child protection process. And this is a very complicated issue. It's very nuanced. It's different than all other areas of law. And so I am going to do my best to present it as clearly as possible, but please do send your questions in so that I make sure that I'm explaining it in a way that's clear and understandable to everybody. When I drafted this, when I wrote this training, I was focusing on serving survivors who are accused of child abuse or are the parent in the child protection matter who's been accused of maltreatment of some form. It is also possible that in working with victims, we're supporting them through a child protection matter where their prior partner or their abuser is the person who's alleged to have committed the maltreatment against the child. And that still may require the parent to be, our client parent, to be involved in the process. Because I'm primarily focusing on the parent who has been accused of maltreatment, I'm going to focus from that point of view. But hopefully, as we talk through the process, you can take other ideas and scenarios of where our client is not the maltreating party, but still understand what this looks like and what it means for them. Also, we're going to be doing a part 2 of this in January of 2020. We know that this is confusing and long and detailed, so as I try to do this overview and make it as clear as possible, please do send in your questions now to Ty, but also between now and the January webinar, anything that you think of as we've talked through it that wasn't clear or you need a review on. We understand that this is not all going to make sense or be memorable, and so if you hear something that we've talked about through this training as you're working with a client and you say, oh, I think that Amy talked about that in the CHIPS webinar, either feel free to go back to the YouTube channel and watch it again or call me and I'm happy to talk with you or your client to the best that I can. We'll talk about some limitations to that in a little bit, but I just wanted to make sure that we're all on the same page here. So, as in any area of law, in working with domestic violence, we all have our own acronyms and phrases that we use that aren't commonly used to other people. So child protection is the same in that way. And so I want to go through these because it is my second language to speak CHIPS language. So if I slip up and don't describe a term fully and use an acronym, this is what they mean. EPC is Emergency Protective Care. We'll be talking about how children can be taken out of the parent's home on an emergency basis, and that's through an EPC process. Social worker or child protection worker is commonly referred to as SW in writing. Child Protection Services, or CPS, I'm sure you've heard that acronym before. CHIPS is a child in need of protection or services. TPR is termination of parental rights. ICWA is part of the Indian Child Welfare Act. It's a federal statute. OHPP is not usually said, but is seen a lot in writing and is referring to an out-of-home placement plan. Best interest of the child is usually shortened to BIC, and people talk about guardian ad litems all the time. It's shortened to GAL as we're going through some of these. So as you see those in the PowerPoint and hear me talking about them, I just wanted to give you a heads up so you can look back to that and consider what they mean. So whenever people hear about CHIPS, they're not thinking about children or court. So my dad joke for the day, I promise this is the only one that's at least written in the PowerPoint, is I want guac with my chips or salsa or something. That's not what we're talking about. We're talking about the child in need of protection and services process. So juvenile court is its own separate, complete part of the government system. Even if you live in a small community and one courthouse or one judge is hearing all different kinds of cases, they're actually different courts that are taking place. Juvenile court is where child protection matters are placed. It's also where juvenile delinquency and some other matters are also happening. And child protection in juvenile court is completely separate from any other kind of proceeding. In fact, it can bring other kinds of proceedings to a screeching halt. We'll talk about it a little more in detail as we go through this, but if there's a family court proceeding regarding custody or parenting time, or sometimes even an OFP that involves custody or parenting time, if a CHIPS action is filed, both of those proceedings, the custody, divorce, or custody in an order for protection, have to stop. Juvenile court has exclusive jurisdiction, which means that family court does not have jurisdiction over a child who is whose maltreatment is being addressed in juvenile court. So it's completely separate. Sometimes cases can be happening at the same time, such as criminal process can happen alongside of a CHIPS process, but other civil and family matters stop. Minnesota Statute 260 is the statute that addresses juvenile court, and we'll go through the different areas of that in a little bit too. So juvenile court is separate from criminal court, although they do sometimes overlap. Parents can be charged with a crime of having committed an act of violence against the child, and they can also be served with CHIPS paperwork or have to deal with CPS for that same act. It is, however, separate from family court. If a case is open in juvenile court, the family court has to pause and nothing can happen until juvenile court proceedings are completed. I have had cases where judges have still taken an OFP or a family court matter. I'm telling you what the law says, not what always necessarily happens in practice. I've also had cases where the court orders that everything else stop and waits for the CHIPS matter to be completed before carrying on with the rest of the civil matters. So it's important that you know your specific county and your specific judge and how they're going to handle that. If there's a CHIPS matter and you bring an OFP, are they going to hear it or not? It's important also to remember that not all cases that Child Protective Services is involved in are actually open in juvenile court. Child protection starts way before a case is ever filed with the juvenile court. So just because they have a social worker or CPS is investigating something doesn't mean that the family court and OFP can't proceed. It's only after the county files an action in the juvenile court. If you're confused about this, do not feel bad. Most people are. My personal background is that I was a child protection prosecutor for 10 years. I lived and breathed this stuff and knew it backwards and forwards. And I was a child protection parents attorney, defense attorney for 3 years. So for 13 years, this was my life. I've been away from it for 7 years, and I look back at it, and I was so confused in writing this PowerPoint because things change so quickly in this area. It is not something that lay people that are not actively involved in child protection cases are going to be able to keep up on. So it's important that you don't feel bad about that and call us anytime. The purpose of child protection is to protect kids from physical, sexual, emotional harm or neglect, and to provide for their safety, security, and welfare. This is to protect them from parents, caregivers, guardians, custodians who are harming them or neglecting them, siblings, and also from the government. There's significant oversight of these cases by the courts. Hearings are held at least once every 3 months to review it. The history behind that is that sometimes if children had a learning disability or a mental health issue, they could get placed in a state hospital or an institution and become institutionalized. Their parents could just throw them away. This is back before the 50s. But that's where this stemmed from, to protect children from the government, from their parents, from their siblings, from anybody who was causing harm to them. There's a lot of different statutes, and I'll tell you which ones we're going to focus on today. The DHS, Department of Human Services website has some really great resources. I used a lot of their information in this PowerPoint here because it's laid out very clearly in a way that parents and lay people can understand. And so if you do have a client who comes in and needs help with how they're going through this process, this DHS website is really helpful and might be a good place to go back to. Things that also affect child protection include the Indian Child Welfare Act, which is referred to as ICWA, and the ICPC, the Interstate Compact for the Protection of Children. That's often used if children are going to be taken from custody of a parent in Minnesota and given to custody of someone in a different state. The social workers in Hennepin County cannot go to Oregon and do a assessment of a family out there to determine if it's a safe and appropriate placement for a child from Minnesota. However, that person in Oregon might be grandma and be very close to the child. But because the social worker from here can't go there, the Interstate Compact is enacted so that a social worker in Oregon would do the home study and report back to the social worker in Hennepin County to say, yes, this is an appropriate placement or it's not. So Minnesota statute has 5 different sections to it of the 260 statute, which is basically the Bible for child protection and juvenile court. 260A deals with truancy, which is typically children who are 12 years old or older who are refusing to go to school. Education neglect is different and is not handled under 260A. That's for children under 12 whose parents are not getting them appropriate education. 260B is our delinquency criminal code. 260C is where we will be focusing most of our attention and where most of the information about child protection statutes occurs. 260D is the children's mental health section, which is if a child, again, were to need to be placed in a group home or treatment or something like that for their mental health, learning significant developmental disabilities, or chemical dependency treatment. 260D, I believe, covers all of that. Minnesota Rules of Juvenile Protection Procedure cover a lot of information, a lot of details about how many days has to happen before this kind of hearing. How long can a child be held out of the parent's care before a parent gets to see a judge? Most of that's not going to be important to you, but I did just want to list out all these resources so that you know where you could go to find them if you needed to. And again, on the bottom, in January, we will be doing part 2 of this webinar. So how can you as advocates best support your clients when a child protection matter is going to come up? And I think having kind of a general idea of what this process means and looks like is important, but always, 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 we stress having those relationships with your community, with your other service and system providers who your clients may be coming into contact with. And obviously doing that before you have a client who's working with Child Protective Services is always going to be helpful. There are often clashes between Child Protective Services and advocacy through domestic violence or sexual violence centers. And that's because we're looking at things from a very different point of view. Everyone obviously wants what's best for the children, and people have different opinions of what that is. I think the area that these two service people clash in most often is that child protection thinks that if a person is working with an advocate, that the advocate believes everything that they say and that they support them 100% in whatever they want, rather than that you're there as a support to provide guidance and to provide options and to make sure they're understanding everything that's happening. I think that they think that advocates believe that if a person has been a victim of domestic violence, they should get a pass, and any abuse that happened to their child is incidental. I'm not being super articulate in how I'm phrasing this, because as advocates, we are there to support our clients to make sure that them and their family are safe no matter what. And when we feel that child protection has overstepped some bounds, we want to advocate for our client, and that's appropriate. Child protection might feel that they have the children's best interest at heart, and even if mom was being abused, she should have made sure that the children were safe, and that having a domestic violence partner does not excuse the fact that abuse has occurred to the children. And so child protection sometimes will remove children from battered women, blaming the mother for not protecting the children, when we have some more background information and an understanding about domestic violence of why she may have made some choices that don't seem to be in the best interest of the children on their face. When you actually look at why did she let him back? Because if she didn't let him back, he was going to kidnap the child and kill him, or something like that. So having different point of views, coming in with different information. In my experience when I was a prosecutor, the advocates didn't love working with us. So coming from the front end, before you have a family that you're talking about, before you have a clash, before there's any issues, developing those relationships, talking about your role, understanding their role, and how you can help each other to both provide the best service to your client. And then when those cases do come up, you'll be able to have conversations, and you'll have that relationship to then best be able to support your client.
I think
So,
that's a great point that you bring up, Amy, about building that relationship prior to a case happening. I was
mhm,
at a child protection um, um, I was at a training for child protection workers, and one of the concerns that was brought up by child protection workers is the lack of relationships that they have with advocates in community advocacy programs, because I think that what they were expressing was that they often butted heads a lot.
mhm.
So child protection workers and advocates often butted heads a lot. And so they was talking around how is there a way that they could build relationships with advocacy and things, because bottom line is safety of the child, right? And so there is a common denominator in this. And so I think that the point that you made, Amy, about building a relationship prior to even having to work with a family around these issues is important, and having child protection know that your program exists in the community, and familiar of faces and names and things like that to best help families, I think is really important.
Thanks, Ty. I'm glad that Child Protection is talking about that at their trainings as well. Um, and there's lots of different ways to do it, and making sure that they do know you exist, that there is a safe place for mom to go if she needs to leave the house to be safe for the kids. That there are services to support her and help her with that part, because that's not Child Protection's role. And so partnering with them is great. The Children's Justice Initiative, I believe most counties have one of these teams. It's made up of multidisciplinary people, typically systems and court people, but there's no reason that your local agency wouldn't be able to participate in these. They're a court set up committee. They typically include social workers, prosecutors, public defenders. Sometimes schools are involved in these, sometimes judges, sometimes mental health providers. And it's not about specific cases, it's about working together to have those relationships and to make modifications to the flow or the way that these cases are being handled in that specific community. And so asking to be part of the Children's Justice Initiative might be a great opportunity. And then if they did have a opportunity where they were going to be discussing a specific case, you obviously can't share any information if that was your client, and you might want to step out because you can't share information about what happens in these meetings, and so you do not want to have information about your client that you're not able to share with them. But because it's rare that they do specific case consultation, I think meeting these members, even if you didn't become part of the team on a monthly basis, showing your face at the table, making sure everyone there knows who you are, I think can be a huge benefit to our clients as they go through this. Did you have anything else about that, Ty?
No, I think that's a good point around confidentiality that you mentioned, Amy. I know back in the day I was a part of a task force that it was called different, but it was with a similar focus as what you're talking about. And there would be occasions where they would talk about, and this is with the school system as well, where we had to sign releases and things to be a part of this committee, but
Mhm.
sometimes information would be shared around particular families and things, and issues that were happening with the children in that family. And as an advocate back in the day, I would have privileged information that I knew from working with that family, and I would never share that in those meetings. And so just an understanding that if you're going to be involved in those types of meetings, having a conversation with the facilitator of the committee first and letting them know like where your boundaries lie in that is really important.
Yeah, that's important. Thank you. Um, so when I was a prosecutor, one of the things I noticed after some time was that one attorney, the clients who were served by that public defender regularly had their rights terminated to children. And another attorney who practiced law very differently never had a case where her clients parental rights were terminated. So I started to kind of watch and see what the difference between them was. And what the difference was that the first one wanted to fight against child protection and show the court everything that they were doing wrong and they weren't following specific rules, and became very adversarial and very aggressively clashing. I kind of lived in a pie in the sky fantasy world when I started doing this, and I thought, child protection is great. Everybody's on the same team. We all want what's good for the kids. We're just here to help you do that. And then I learned parents don't think that we're all on the same team when social workers come in and take the children out of their house, which is absolutely true. I wouldn't either. There's lots of reasons why things happen. Parents think that it's unfair, it's unjust, it's wrong. How can they do this? And a lot of times I agree with them and I understand. But as an attorney, going in to fight all those things distracted the client from doing the work and the things they could have been able to do to get their children back or to keep the children from being removed. And I don't mean this in a disrespectful, fake, jerky way, but literally the most successful cases that I saw were when the parents cooperated with the social workers. Even if they disagreed, they said, yes, ma'am. So the advice I gave my clients that started working when I was doing the defense part: follow the case plan, cooperate, return their phone calls, go to meetings when they want you to, do what they ask you to, ask them if you're doing it right, ask them what more can I do, smile while you're doing it, and thank them for helping you with your family. The people who, and I don't mean this in a like cheesy way, like, ask me how high I have to jump and I'll do what you say, social worker. But something led to them being involved in your life. So acknowledging, yeah, this is really hard and I need some help with this right now. Thank you so much for helping me with it. And the social workers then it was kind of like a snowball effect. Like, oh, I'm happy to help them because they want help and they're making huge changes and I see the changes and the kids are doing great and I'm going to get out of their life now because everything's good, versus I'm going to spend all my time talking to my lawyer and fighting about how much what they're doing is unjust. So you can have this conversation with them that it's hard and you know it's hard and you know they disagree, and yeah, it wasn't fair that the social worker said this. That's not what actually happened. But your goal is to keep your children and to keep your children safe. So go to therapy, go to parenting class. You might accidentally learn something while you're there. Everyone needs help with parenting. Goodness sakes, my kid's 27 next month, and I wish I had a magic book of how to be a good mom. So viewing child protection as a support and a help rather than an enemy goes a long way, and helping our clients to maybe see that, even though they feel very threatened or very scared for their kids, can help the system move along better. So we will now start talking about the process. What happens from the beginning to the end of a child protection case? And it starts with a report to law enforcement or to Child Protective Services. There are mandated reporters and we have trainings on them. You probably received lots of information about it during your 40-hour trainings when you were becoming advocates. And if you need training on that, call us and we'll come out and do it for your agency. But other reports also come to child protection other than through mandated reporters. If a crime has occurred, a child has been injured, somebody's been hurt, or people notice maltreatment of some form against children, they can call law enforcement, who will come and do an immediate assessment and then will also cross-report to child protection. Or you can call the child protection hotline to make a report. And if it involves something that would be a crime, they cross-report to law enforcement. So you can't pick and choose one. If it's a crime, it's going to both, no matter what happens. Besides mandated reporters, lots of other people can report. You can be driving down the street and see a 3-year-old out on the sidewalk by himself, and there's no parent here. I'm going to call, and maybe it's because he ran away while mom was sleeping, or maybe it's because mom is high and doesn't know where any of her kids are, and thank you, officer, for bringing him home. Family members can report, grandparents report things that they're concerned about happening to their grandkids. And parents often report maltreatment of their own children to child protection. If something is maltreatment and it needs to be addressed, the report needs to be made. I caution parents about making child protection reports when they're in the middle of a custody battle, when they're going to file an OFP, when it's going to be misinterpreted or at least twisted and used against them in a future process that may be a better way for them to protect their children. It gets really complicated when child protection reports are made when they're involved in a custody matter, because we hear responses from parents saying, for example, mom reports that dad sexually abused the child on a visit. Dad accuses mom of malicious reporting, saying she's just making stuff up and saying I did something because she wants full custody and she wants to move away. Or people do make false reports of allegations of maltreatment because they want to have a step up. In the similar way that we hear judges talk to our clients about an OFP is not an appropriate way to address custody. If you want to get divorced and address custody, go to family court and get a divorce and have a custody hearing. Do not do it through an OFP. If the child is not a victim of domestic violence, do not include them on behalf of for part of the OFP. The same way that we hear judges get testy about that and send those back, saying that they really belong in custody court, those custody judges, the family court judges, also feel the same way about child protection if repeated reports are made, because they assume that they're false or that they're malicious or that something regarding the court case is really the motive rather than the safety of the child. So in saying all of that, I am not saying don't report, or if something's happening, don't take the child to MCRC or corner house or a forensic interview to talk about what's happened to them. But be aware of what those negative implications could be. Another thing that I want you to be aware of just in general is that if somebody comes to you after child protection has filed a CHIPS petition in court against them, that so much stuff has happened before that even gets to court, unless there's a significant emergency. So a client may be coming to you at the time the court action is initiated, but they might have been working with CPS for years. So trying to probe into what happened in their specific case is important as you support them. If they're meeting child protection for the first time and there was an emergency and their children were removed, that's a very different situation than if, well, yeah, for the last 7 years, they're kind of popping in and out of my life. I know what's going on. Now they filed a CHIPS petition against me, so now they're real serious. But if you don't have the understanding of the last 7 years, you're going to be at a disadvantage of how to support your client. Another thing about why it's important for advocates to understand CHIPS is because when a client does come to you and talks to you about a CHIPS proceeding has happened, they don't want to be the one to have to educate you about what that means. That makes them feel like they can't trust you. So if you have a basic understanding and then can call standpoint on things that you're not familiar with. And also understanding that this is a traumatic event. This may trigger PTSD. This may trigger lots of trauma from the past for the parent and the child. They may be in a very trauma fog as they come to you. So understanding that, obviously having your child removed from your care or having the fear that somebody's going to remove your child from your care is terrifying. Okay. What is maltreatment in Minnesota? When they receive a child protection report, what is the Child Protection Agency screening for? So neglect is the most common form of maltreatment, and it's usually a failure of the care provider to do something. One of the main ones is to provide basic care, which includes food, clothing, shelter, physician, medical treatment, mental health, education, supervision, appropriate for their age and circumstances. Protecting them from things that would endanger them, not having them educated as required by law. Like some homeschool people don't get their program registered. It's totally legal to do homeschool, but you have to be registered with the homeschool process, and the curriculum has to be taught a certain way. If that's not happening, that's a problem. If a first grader's missed half of the school year, that's going to be a problem. Exposing a child to drugs during pregnancy, causing emotional harm to a child, exposing them to criminal behavior, those kind of things are neglect, and that's the most common form of maltreatment. Physical abuse, obviously, is when the caregiver causes any physical injury or threatens harm or substantial injury on a child other than by accident. If I'm going to wave my arm as I'm telling a story and I backhand my kid in the face as they walk past me, that's an accident, even if they have a big handprint or bruise on their nose. If I cause injury to them by any non-accidental means, it's physical abuse. And it can range from minor bruises to severe internal injuries or even death of a child. Mental injury is really difficult to quantify or describe. You kind of know it when you see it. You're going to see children acting atypical for the age, for the circumstances, for the environment. And that mental injury is caused by emotional harm to the child's psychological capacity or emotional stability, evidenced by an observable and substantial impairment of the child's functioning. That might require a psychological evaluation to determine, or it may be really obvious to the third grade teacher on the first day of class. And then sexual abuse is when the child is a victim of a criminal sexual act or a threatened criminal sexual act committed by a person who's responsible for their care, who has a significant relationship with the child, or who's in a position of authority over them. So if a child is sexually assaulted by the 8-year-old next door and the child is 6, that is not a child protection issue. That is a different kind of issue. It might be a child protection issue for the child who did the act, like why do you know how to do that and who's harming you? But for me, if my child went next door and was assaulted, that's not me maltreating my child. So when they receive a report, those are the things they're looking for. Did one of these things occur? And if it's screened out, if they say what the information that we have does not rise to the level to say that we have enough information to say that one of these acts occurred, they're going to screen it out. They're not going to contact that family. They're not going to go to that residence. They're not going to investigate it. If they screen it in and say, oh, some kind of maltreatment has been reported, It doesn't mean it's been substantiated or determined, but we've received a report significant enough to screen it in. Then we have two options. We'll either complete a family assessment or a family investigation. So the family assessment is the first one. Counties and tribes use family investigations for serious reports of child abuse and neglect, and that includes cases where children are in imminent risk of harm. But for many families struggling for what's best for their children, a family investigation isn't needed, and so a family assessment response gives Child Protective Services the flexibility to decide how best to meet that child's and family's needs. Extensive research has found that children are safer and families are healthier when support services are quickly made available and targeted to their specific needs. With this approach, child protection examines the child's safety and maltreatment risks, but also looks at the family's strengths and needs. So they're coming in along the family as a partner and a support, not as an investigator. This allows the social worker to better support the families and refer them to community resources that can be available. And again, having those relationships with child protection makes your services known and able to be referred to by the assessment social workers. When families lack some of life's basic necessities like adequate food, clothing, transportation, healthcare, safe and affordable childcare, they might not be able to safely care for their children. And sometimes they need services like counseling to address relationship concerns or child behavior, chemical dependency, or parenting education about such topics about child development and physical discipline. What's appropriate? How do I consequence my child to make him stop doing this without being abusive? So the social worker in those circumstances can connect the family with resources to address those unmet needs, which reduces the stress for the parent and lowers the risk of child abuse or neglect for the child. Social workers can help families identify strengths to build on, which helps to keep children safe and improve the family's life. Identifying what parents do well, like you obviously provide a great home for them, you show them affection, and talking about what positive things you're seeing in their family offers the family more possibilities for well-being than if we're in there documenting their failures. So the goal is always to use a family assessment unless a child is being harmed. So building on the strengths, calling in family resources, relatives, friends who can help problem solve or provide assistance helps parents raise their family in safe, healthy, and nurturing environments and minimizes the negative labeling. People don't want to be determined to have committed maltreatment. They don't want to be in court for having harmed their child. And this provides them with some autonomy in what they can get from the county and how the county can help them. It also provides them with grace to be able to not be judged and not be documented and not be told what they're doing wrong. So in an assessment, no determination of abuse or neglect is ever made. The parents are not labeled as abusive or neglectful, and it's usually considered a more effective and empowering way to address child protection concerns. Including the community is also one of the main parts of this. They can help link struggling or isolated families with resources, including schools, neighborhood centers, faith-based organizations, food shelves, child care centers, family daycares, neighbors, extended family, and supportive social service agencies, which decreases their isolation, leads to greater safety for the children, and builds a stronger community by ensuring that all the families who are struggling are getting help without government intervention and the government stepping on their toes and telling them how they have to raise their kids. In more serious cases, a family investigation is done. So a lot of this information that I'm sharing is on that DHS website. So just to give credit to them where that is due, and to point you to another resource again if this is happening with one of your clients and you want more information on it. So every year, Minnesota receives approximately 18,000 reports of abuse or neglect. The majority of the reports are handled through family assessment or screened out, but about 30% of them require a family investigation. An investigation has to be done when a child is in immediate or significant danger, the family refuses to cooperate with a family assessment or take steps to make sure their children are safe, and child protection investigators focus on the child's safety and strive to engage the family in a positive working relationship whenever possible to resolve the issues. And most families successfully resolve the issues and don't need services beyond the investigation. So this investigation is a little more direct and may feel more judgmental as they're looking into what has happened and is the child safe. But it also is designed to create a supportive environment and not lead to the filing of a CHIPS petition. So during the investigation, the Child Protective Services social worker, sometimes along with law enforcement, interviews the child who's the alleged victim of the maltreatment. They can go to the child's school and talk to the child without the parent's knowledge. So that's something that's often a shock and surprise to parents to find out that law enforcement was talking to their child that day. They do talk to the child's parents. They talk to the alleged offender who's committed the maltreatment. And they talk to other people involved in the child or the family's life, like school staff, medical providers, or anyone else who might have information regarding the child's safety. If there's criminal allegations, again, law enforcement will be involved in this assessment along with the social worker and assess the child's safety and risk of possible future maltreatment. If necessary, the worker and the family create a safety plan to ensure that the child is safe and the child remains in the home. That's always the goal. Unlike an assessment where no determinations are made, if an investigation is done, the social worker needs to make two decisions or determinations in every case. One, they determine whether abuse or neglect occurred. Two, they determine whether protective services are needed to ensure the child's safety moving forward. If no abuse or neglect occurred, they may simply stop the investigation and be out of the parent's life at that time, or they may offer voluntary services or to go back to a family assessment to get supportive services from an ongoing worker. If abuse or neglect was determined and maltreatment is determined, that doesn't necessarily mean that services are going to be required. If it was a one-time thing or mom didn't know about it and found out, and now the perpetrator no longer lives in the house, mom has taken appropriate steps to protect the child feels safe to talk to mom, maybe the child's in counseling, lots of things have happened that mom's done that child protection no longer needs to be involved to fix it or help support her. So social workers have 45 days to complete their investigation and make these two determinations. And they're required to notify the parent and the alleged offender within 10 days. If the parent or the alleged offender who maltreatment is determined against disagrees with the determinations, they have the right to ask child protection to reconsider it. Typically, they write a letter that goes to the social worker's supervisor, and the supervisor then reviews the file and all of the interviews and everything to see if they agree with the determinations. I don't know if I mentioned this, but these interviews are recorded on audio cassettes and can be transcribed if needed. And it's a way to protect both the social worker and the parent from things being misconstrued or twisted against them. If the Child Protective Services refuses to overturn the decision of the initial social worker, the parents then have the right to ask for further reconsideration by the Minnesota Department of Human Services, which can lead to an administrative hearing, which it's called a hearing, but it's a very informal conference with a administrative law judge who's not a district court judge from the Department of Human Services who hears mom's testimony. She may have a lawyer presenting information for her of why maltreatment should not have been determined against her. And then the county attorney typically represents the social worker in supporting why the determination was appropriate. When services are needed to ensure the child's safety, a child protection ongoing social worker will be assigned. And this is a new social worker, not the investigative worker, who will meet with the family and again, try to assess their strengths and needs and develop a service plan to address the child's safety and other issues that impact the child and the family's well-being. That social worker has 30 days to develop a service plan along with the family that includes goals and steps to take to address the identified concerns, whatever the concerns the investigation resulted in. In most cases, these parents agree to work with child protection, and if a parent or caregiver refuses to participate, that is when the ongoing worker would consult with the county attorney or the tribal attorney, and a CHIPS petition may be filed, seeking either temporary legal custody of the child or for placement in foster care can be considered if child protection or law enforcement believes that the child is not safe in the home of the parent. This can happen after the child's been home sometime and the mom is still not working with child protection to ensure the child's safety. They may determine that it's no longer safe for the child to remain there and may seek temporary custody of the child. Only law enforcement and the court has the authority to place a child in foster care. CPS can't make that determination on their own. They can file a petition and ask the court to authorize it, at which point then law enforcement would go out with them to enforce the order of picking up the child and placing them in foster care. If the social worker believes that the child needs to be placed for the child's safety, they can ask the parent to sign a voluntary placement agreement. If they don't want to sign that, the social worker can ask law enforcement to place the child on a 72-hour hold where law enforcement has the authority to remove the child from the home and place them in foster care for up to three days, at which point a CHIPS petition or an emergency protective care petition would need to be filed, and they would have a hearing in front of a judge. Anytime a child is placed in foster care, the social worker is supposed to ask for names of relatives or friends who could provide a safe temporary home for the child. And that's because we recognize that out-of-home placement is extremely stressful, both for the parent and child. And anytime the stress can be decreased by placing the child with a person known to the child who can safely care for them, reduces that stress. If I know, okay, they took my child away, but she's with my sister, I know my sister will take care of her for 3 days until I get to talk to the judge. My child knows my sister and her kids, they're her cousins. She's just going to go have a sleepover for a few days until we get to talk to the judge. That's a lot less stressful than they took my child and placed them with a stranger I don't know, and I don't know the address, and is my kid okay? And they're probably crying because they don't know what happened. Like that traumatic thing can spiral very quickly. And so kinship placements are always supposed to be a first option. So EPC, the Emergency Protective Care, is a way that children can be removed immediately for their safety. Law enforcement can place the child on a 72-hour hold without a court order, or Child Protective Services can petition for that order from the court for an EPC. And it's an ex parte order, so they submit, similar to an OFP, they submit their affidavit, their request for that emergency signed by a judge, which can allow them to take the child to an appropriate relative, foster home, or shelter, pending the EPC hearing, which is like the initial OFP hearing. State the name and address of the child unless such information would endanger the child. I can't think of an example where I've seen that occur, why you wouldn't name the child. So this order and what the Child Protection Agency has to include in their petition is all of this information on this slide. The age and gender of the child, general description of what the child looks like, why the EPC is necessary, any limitations or time or location of the execution of the order. Maybe the judge will say you can pick the child up from school and bring them to foster care, but you're not going to their home at 11 at night and picking them up out of bed. That's terrifying. And then specifically state the date, time, and location of the EPC hearing, which needs to be provided to the parent right away so they know that they're going to get heard, when they're going to get heard, and how that's going to work. So parties to an emergency protective care or child in need of protection and services petition most commonly qualify for a court-appointed counsel. So this is at no charge or at a minimal copay to the parent. Parties who also can have attorneys are children over the age of 11, the social worker who is represented by the county attorney, the guardian ad litem, and the defense attorney. Other people can intervene and ask to be part of the case, to be a party to it, so that they have a voice, they get to say their opinion. So that sometimes can include grandparents who the child has lived with in the past, foster parents, the tribe if the child's an ICWA child. So because they're appointed an attorney so early in the proceedings, it gets a little tricky for Standpoint to be able to provide legal advice on these issues. So we're not usually able to talk to the client because they have an attorney and they're represented, so it's unethical for us to do so. But we can provide strategies to advocacy and support you through how you can support the parent. Maybe tell you if what's happening in a case is common or legal or normal. We're also happy to talk with the attorney about how domestic violence or sexual assault might impact their case or be a defense for whatever has occurred. And parents oftentimes call and want to fire their attorney so that they can talk to a different attorney. And that's fine. They absolutely have that right. But you should be aware and talk to them about the risk that they have of doing that. So if they fire their court-appointed attorney or public defender, the court is not obligated to appoint a second or different public defender or court-appointed attorney to them. So they might have to go through the rest of the case without a lawyer. And these cases are very complicated and have huge risks. Sometimes people talk about these being the highest risk case because losing your child to a termination of parental rights is, to some people, worse than going to prison for the rest of your life. Having an attorney for these is super important. Parents don't always like what the attorney is advising them. The attorney, most often, because they're a public defender or court-appointed attorney, knows this system in this county. They know this judge, they know this social worker, they know this county attorney, they know what these cases look like here, they know the best ways to defend their clients. And so they have tons of experience in this system and are probably providing the best advice to help their clients, even if it's not the advice that the client wants to hear. Going back to that slide where we talked about telling them to cooperate, and return phone calls, and do what the social worker asks, attorneys are often going to give that same advice because it's the best way to keep their children with them. And clients don't always like to hear that. So we've talked about ICWA a couple of times. I just wanted to kind of explain the very high level stuff you might need to know about it. So ICWA applies to children who are eligible for registration in a federally recognized tribe. They do not have to be enrolled in the tribe. The tribe does not have to know them. They just have to be eligible for registration. And if a child is determined to be an Indian child, the state, the county attorney, and the social worker are required to notify the tribe. Anytime that a child is removed from the parent's home, a qualified expert witness is required to be called to testify about the best interest of an Indian child. And that qualified expert needs to be somebody from the same tribe and band as that child who can talk about specifically, this is how we raise our children. This is what is best for our children. And that expert might support placement right now because the way that the parent is parenting is not appropriate with our tribal beliefs. Or may say, yes, that child should be placed, but they need to be placed with our tribe, with a foster parent in our tribe, not into the county. District court, the juvenile court, like we've been talking about, is the one who handles these child protection cases. But you should be aware that tribal court has the authority to pick up a case out of district court and take it to tribal court. And then the county, the social worker is still a witness and they're working with the tribe. But the county attorney's office, the district court judge, and the public defenders aren't necessarily the same people involved. It's handled through the tribe. Because I am not licensed to practice in tribal court, I've never seen what that looks like. I have had social workers that were going to tribal court and working with the tribe regarding Native children, but I can't speak to what that looks like exactly. So when the county has filed a CHIPS or a permanency petition regarding an Indian child, they have a higher burden of proof to be able to show. For a non-Indian child, the burden that the county has to prove is by clear and convincing evidence. It's clear that this is what's best for the child. It's not beyond a reasonable doubt, but it's the next step down of the evidence that has to be proved. In an ICWA case, the burden is beyond a reasonable doubt. You can't terminate an Indian child's parents' parental rights unless you have proven the case beyond a reasonable doubt. It also requires a higher level of service to the family. So for non-ICWA families, the agency or the social worker, I often refer to CPS as the agency, is required to provide reasonable services to keep the family together or to reunify the family if the child's been placed in out-of-home placement. For an ICWA case, they have to do active efforts to keep the family together or to reunify them. That means I'm not giving you a phone number of who can help you with finding housing. I'm walking with you to find that housing. I'm doing active efforts. I'm not doing supportive efforts. And the reason behind ICWA and the reason for this law is based in the history when Indian children were placed in boarding schools or were placed in foster care regularly and were removed from the tribe, removed from their people, their language, their culture. And these laws exist now to try to protect them. The statistics show now that Native American children are placed in foster care still at alarmingly high rates compared to other identified people in Minnesota. And we still need to be working on this. So ICWA is a really important law for that. And one thing about that, however, is to know how it works in your county, in your specific system. Sometimes it can backfire on a family. So you want to know if a client of yours identifies as Native or believes they may have significant blood quantum for them or their child to qualify for enrollment in a tribe. It may be best to push for that, but in other cases where ICWA isn't followed as closely or it can backfire, they might not want to expose that or try to claim that their child is eligible for enrollment. So knowing your specific community is important. There is an order for protection statute in the child protection statutes. When I was practicing law, I would get very, very frustrated when child protection would tell my client they had to go get an order for protection. Going to get an order for protection is not always safe. There's lots of pros and cons to it. And then oftentimes when they were told to go get an order for protection for the child, they didn't qualify under Minnesota Statute 518B because one of those 5 requirements of what defines domestic abuse had not occurred. Something that might be bad parenting or child abuse or child protection matter might not qualify under the OFP statute. However, it would qualify under 260C 148, which is the child protection order for protection statute. And so if social workers are pushing your clients to get these kind of regular OFPs and you're not seeing that they qualify, or you think that your judge is going to view it as a ploy regarding custody, ask them to file the OFP under this statute instead, and ask the social services agency to file rather than requiring the parent to file. So one of the most important things I think that this can do is exclude the abusing party from the home, which judges get confused about and social workers get confused about, and this law has been in there forever and people always forget about it. But how much less traumatic is it to have the alleged abuser removed from the home under this order rather than the child placed in foster care or a group home or a shelter or a relative even? So when there's reasonable grounds to believe that a child is in immediate and present danger of domestic child abuse, the court can grant, just like in family court, the ex parte temporary OFP, and then a hearing's held within 14 days after the service of the ex parte order on the respondent. These only last for a year. Typically, following one of these, if the remaining parent is safe and the protective parent is doing what they need to do, a child protection matter doesn't need to be brought. But if the parent is allowed back into the household or pushes their way back into the household, a child protection matter could then be brought and still use this statute to remove the abuser rather than place the child in foster care. So having this handy and being able to tell your clients about it and being able to maybe remind a social worker about it can be great for kids and for your clients. So I just wanted to point that out. How are we doing on time? Okay. I don't think we're going to make it through all of this. We're going to do our best. And like I said, we do have that January one scheduled. So we'll come back to what we haven't finished and address more of your specific questions at that time. But Ty, right now, do we have any questions from anybody?
No, we don't have any questions. The January webinar, I will send the link for registration through the listserv, just so folks know. I haven't sent that out yet, if people are wondering.
Thank you. ADR is what is referred to as alternative dispute resolution. And there's several different processes, just like in family court when our parents go through social early neutral evaluations or custody evaluations or mediation. There's similar processes in juvenile court to try to resolve these cases as well. Family group decision making is one of the processes that is used by the social service agency prior to filing a CHIPS petition typically. So they call a meeting of all the parties involved, the parents, the child, supportive people for the parents, supportive people for the child, relatives, teachers, whoever is this family's support. I've been part of family group decision makings for friends of mine who were struggling with mental health or chemical dependency because I was like an honorary auntie to their children. and they could talk to me. And so going in and talking with social services, so everyone's on the same page, everyone knows what an emergency safety plan is going to look like. Everyone supports that the children are not going to foster care, they're going to Auntie Amy's house. And when mom's stressed, she's going to call her sister and they're going to talk about this. And when if mom relapses, she's going to call the social worker and tell her, and the social worker is not going to take her children. The social worker is going to follow the family group plan that was made at this meeting by all of the people who love these children. Typically, a guardian ad litem isn't involved because they haven't gotten that far yet. A family group decision making can take place after a CHIPS petition is filed, but it's typically used beforehand to make a plan of what's going to keep this family safe and out of child protection's realm. A parallel protection process is a process that takes place after the CHIPS petition is filed, but before a CHIPS trial would be held. So in this process, the county attorney, the social worker, the guardian ad litem, the parents' attorneys, the child's attorneys if they have one. If the child's too young, they won't be involved in this. The court is not involved in this, but this is designed to be a way to be less adversarial and kind of live in my pie in the sky moment of we all really want what's best for this child. Mom, how can we help you do that? I don't want to bring a termination of parental rights petition against you. I want you to have your children with you. What can we do to support you? And then the parent is involved in, yeah, I do need support about this area. This is my strengths. This is my weaknesses. My weaknesses led to this maltreatment of my child. I don't want my child to be maltreated. I want to learn ABC so that my child will be safe. Then we develop that, we write it into a plan, we submit it to the court, and it's signed, and that becomes the agreement. If that agreement is broken, then we go back to the court process and we might have to have a pretrial and a court trial. But if this works and is successful, we can avoid that whole process and the family feels more engaged because they made this plan. Mediation is something new since I practiced in child protection. I have not seen that used and I haven't seen a good description of it, so I'm not able to describe it for you at this time, but I just wanted you to be aware it's in the statute as one of the options. Like I said, sometimes the child is included in the process and sometimes not, based on either their age or the allegations. And these processes can be used to resolve all or part of the matter before the court hears it. So excuse me. Maybe I don't agree that my child is in need of protection and services, and I don't agree that I did anything wrong, but I do agree I'll do these things we just talked about because that would super help my family. So maybe we didn't resolve everything. Maybe the court needs to decide if my child are in need of protection or services or not. Or maybe they don't. Maybe we have a plan and that's good enough to move forward. I apologize. I have a really sore throat, which you can probably hear, so I'm trying to drink water. And it's disrupting me. I apologize. So the court process and timelines for CHIPS cases are speedy. The purpose of that is to get the family safe, keep the child safe, keep the child in the home as quickly as possible, and not just the court orders the child into foster care and they're just going to hang out there till we get around to having another hearing. So the timelines are pretty quick. If the county files that ex parte EPC taking the child into immediate custody, they are also required to file a CHIPS petition at that time. But an EPC isn't always filed. Sometimes just a CHIPS petition is filed even when the children are still home. So if there's no EPC, the child is home, then the admit deny hearing has to be held within 3 to 20 days after the petition is filed and served on the parties. If there has been an EPC, the admit deny hearing needs to be held within 10 days of the EPC hearing, which is within 3 days of the filing of the EPC and the removal of the child. Oftentimes, the parties will just enter a denial to the CHIPS at that EPC hearing to not have to come twice. A pretrial then has to be held at some point, but at least 10 days before a trial. If the resolution isn't able to happen, there's no agreement, a trial on the petition has to be held within 60 days of the admit deny hearing or EPC, whichever is sooner. So they put these on a fast track. If a child is placed out of the parent's home and they are under the age of 8, within 6 months, the county has to file a permanency petition. There's lots of research and information about how consistency and structure and permanency and knowing where you're going to live and not going back and forth between different houses is best for children. And so if a child under the age of 8 has been placed outside of their home, the court is going to want to get permanency for that child as soon as possible. And if the parent isn't able to create safety within 6 months, they're going to be ordering the social workers to file a permanency petition. For children over the age of 8 and they've been in placement for 12 months, then the county has to file for those same reasons. It's really important that you be aware of this, and that if you hear your client talking about not being able to go to court or not wanting to go to court or oversleeping or something, they need to be very aware that at any point in this process, the court can find them in default if they fail to appear. They can do it at the admit deny hearing. So the very first hearing they've had, the court can say, yes, we're putting your child in foster care and we're adjudicating you to have committed maltreatment of whatever's alleged in the petition. And your child is adjudicated or judged officially to be a child in need of protection and services, which means the court then has jurisdiction over your family. That can happen at a pretrial, it can happen on the day of trial, it can happen at any time. So they have to make sure they're at their hearings. Even if their attorney's there, that's not sufficient. The court does still have to receive evidence in support of the petition. So the social worker might testify, or the county attorney might ask the court to rely on the petitions, pleadings, affidavits, whatever has been presented to the court. The court doesn't have to proceed by default and can reschedule the hearing or grant an order for the relief sought in the petition. They have an option to do either one. So please tell your clients to go to court. So we talked earlier about what are the things that social services is screening for: the neglect, physical abuse, sexual abuse, and emotional harm. To file a child in need of protection and services petition, you have to allege one of 15 things. So we're just going to whip through these quickly just so you know kind of what the basis for a CHIPS can be. So the first one, the child's abandoned, doesn't have a parent, guardian, anyone available to care for them. The second one, they've been a victim of physical or sexual abuse. They reside with a victim of physical or sexual abuse, like a sibling. They reside with a perpetrator of domestic child abuse, or they're a victim of emotional maltreatment, which is consistent, deliberate infliction of mental harm on a child by a person responsible for their care that has an observable, sustained, and adverse effect on their physical, mental, or emotional development. It doesn't include punishment or the reasonable exercise of authority by a person. So that word reasonable is important right there. And the court's the one that determines that, whether that behavior is reasonable or not. The parent doesn't get to determine that. Number 3, the child doesn't have food, clothing, shelter, education, other required care for their physical or mental health or upbringing. This education one is going to be the educational neglect. A child under 12 isn't getting to school. because the parent's not getting them there. Number 4, the child is without special care made necessary because of the child's physical, mental, or emotional disability, and the parent is unwilling or unable to provide that care. And I just want to note, like, all of these allegations don't mean the parent's a bad parent. Sometimes it means they don't have the resources, they don't have the ability. I unfortunately had a client once with Huntington's syndrome, which is a disease that eats your brain and your body. And she had 2 children. One of them had Huntington's syndrome, and she wasn't able to care for them anymore. And she didn't have family. She didn't have anyone who could help her or take the kids. She came to social services and asked for help. And this CHIPS petition was filed to give her and the court and the social services the ability to place the kids in foster care. That was supportive of them continuing their relationship with her. So it's not always like you're a bad person, you're a bad parent coming from the county. It's oftentimes, I'm really, really sorry you're in this situation. We need to help you because it's what's best for your kids. Number 5, the child is medically neglected. This includes failure to thrive, defined and diagnosed by a physician. That's often infants who are not growing appropriately. It can also include withholding appropriate medical care that a physician says is required to keep the child alive or comfortable. Number 6, the parent doesn't want to take care of the kid anymore. I want to be relieved of my child's care because for good cause. So they're not safe in my house because they keep hurting my other children. I agree to place them in foster care because I have an addiction right now, and until I go to treatment and get this under control, they're not safe in my care. Number 7 has been placed for adoption or care in violation of the law. I've never used or seen that. I suppose if you just give them to someone else and walk away, that's maybe a CHIPS, but I'm not sure. Number 8, they are without proper parental care because the parent's emotional, mental, or physical disability or state of immaturity prevents the parent from providing appropriate care. The child is one whose behavior, condition, or environment is injurious or dangerous to the child. This can be including exposure to drugs, exposure to criminal activity, other dangerous things, garbage houses, things like that, meth houses where there's meth being cooked or whatever, and it's not safe for the child. Number 10, again, is a failure to thrive. I'm not sure how it's different from the medical care. Number 11, the child has engaged in prostitution, which is going to be on the parent, not the child. The child has committed a delinquent or juvenile petty offense before becoming 10 years old. Children who are 10 and younger cannot be charged with delinquency or a crime, but if they are committing offenses, they're going to be brought in front of the court anyway. It's probably a lack of supervision issue, but it might just be a way for the judge to say, you can't do that. Little 9-year-old, stop doing graffiti all over town. I like making up scenarios in my head. I hope they're as entertaining for you as they are for me. The child has run away. The child is a habitual truant. This is going to be the child 12 years old or older. So truancy is when the child makes a decision, I'm not going to school. Educational neglect is one of those prior numbers, number 3, where it's the parent's responsibility and they're not getting the child to school. Or number 15, they've been found incompetent to proceed because of mental illness or mental deficiency in connection with a delinquency proceeding. I had a 12-year-old who committed homicide and was incompetent to proceed to trial. He was low functioning. He had significant emotional and developmental delays. And so this CHIPS petition was filed against him, which allowed him to be placed in a treatment center for children. And he was never able to come back to court to address the homicide charges. Once he turned 18, he aged out and was placed under guardianship because of his low functioning. But the homicide was never completed or tried or brought through court because of his incompetency. But we don't just ignore that. This comes to a CHIPS then. Ty, how are we doing for time?
We have 4 minutes.
Are there any questions?
No, there are no questions.
Okay, I'm going to keep talking and you cut in when I need to stop.
Okay,
Okay.
sounds good.
So once they go through the court proceeding, a child protection case has been tried, child protection petition has been filed. Either the ADR process has gone through and they've reached an agreement, or a trial has occurred and the court has determined that maltreatment occurred and that the county proved what they needed to prove. A decision needs to be made about adjudication or a stay of adjudication. And this can be done with an agreement too. The county can always agree to a stay of adjudication. That can be part of an agreement through an ADR process. So what an adjudication does is the court makes a judgment, formally declares that yes, these children are in need of protection and services. They order a case plan for kids who are at home or an out-of-home placement plan for kids who are in foster care. And that is a requirement. The family has to cooperate with this, and every 90 days it's reviewed to make sure that steps are moving forward in the right direction. At an adjudication, concurrent planning and timelines start to run. So if a child's in out-of-home placement, that 8 years old or younger, that 6-month timeline is running. 12 years old or younger, that 1-year timeline is running. That is one of the most confusing parts for families and even attorneys, is the concurrency planning, which is required by statute because of the studies that show that structure and permanency is best for kids. So the same social worker who's providing services to you and working with you to correct the conditions in your home and get your kids back is also planning and addressing what we're going to do if it doesn't work. And so that's very counterintuitive. It feels very mistrustful oftentimes to parents. Wait a minute, how am I supposed to trust or work with my social worker when she's talking to all my relatives and asking them if they'll adopt my kid? My kid's not up for adoption. I'm working really hard to get them back. And so this can be extremely difficult and frustrating, and extremely understandably so. But it's part of the statute, and social workers don't have an option. If the child's not able to return home, they have to have a different plan. It's not so much the same under a stay of adjudication. So if the court does not make that formal declaration that these are children in need of protection and services, the family has up to 6 months, 180 days, to work with child protection to correct the conditions, to go to treatment, to clean up the house, to do whatever they need to do to make it safe for the child to stay home. Typically, a stay of adjudication is most common when children are in the home, not in foster care. I think it could be if a child was in foster care, but mom was doing really good on the case plan or voluntary placement case plan, and they knew they were going to be moving back. So if the conditions are corrected, the county can dismiss at or before that 180-day timeline. If they're not and they need to continue, the county needs to go back to the court and ask for that adjudication to be entered. And if they don't, the court loses jurisdiction on that 180th day and the case is closed. I believe that it's 3:30 and Ty is going to wrap us up.
Yeah, so I am going to wrap you up. What I am going to ask for those that are still present is if you have any questions around the topics and the areas of discussion that Amy had went through, please feel free to email them to me. Or also, if you have any areas that you feel like you want Amy to address for part 2 of this webinar, please also email that to me as well. My email address is thi@standpointmn.org. And so, yeah, we want to cater this webinar to all of you doing this work. And I know as I was listening to this, there was lots of things that I learned that I didn't know. So I appreciate that, Amy, and I look forward to hearing from all of you, and um, stay tuned for part 2. Thank you.
Have a good day, guys. Bye.
Bye.